This motion hearing will come to order. This is in the matter of Raccoon Hill LLC doing business as Docks Riverside Taphouse, OAH docket number 08-2021-LCB-00997. This motion hearing is being recorded and is duly convened before the Office of Administrative Hearings on November 5, 2021 at 10:02 a.m. Pacific Time. Speaking is Administrative Law Judge Terry Hsu. I'm conducting this motion hearing from Tacoma, Washington. Present by telephone is Jason Miller, Assistant Attorney General representing the Liquor and Cannabis Board, Christopher King, member representing Raccoon Hill LLC. Also in attendance are three other members, Jim Sekulich, Brad Sekulich, and Ken Sekulich. There's a couple preliminary matters I want to address first. We've met several times recently, so rather than going through a bunch of addresses, I'm just going to ask people if the contact information needs to be updated from the last time we met. Mr. Miller, is your contact information still current?
Yes, Your Honor.
Mr. King, is yours?
That's correct, Your Honor, it is.
And Mr. Sekulich, the address that we have for you, is that still current? Mr. James Sekulich?
Yeah.
Okay, thank you.
Yes.
And now the other thing is there was some confusion regarding a declaration. So I believe I have everything that parties expect me to have. I want to confirm that. Where the confusion was is on October 22, Raccoon Hill filed its response to the state's motion for summary judgment, and filed a declaration. But the document that was intended, was entitled, or rather wasn't entitled, was represented to be a declaration, which is another copy of the memorandum. In other words, instead of filing two separate documents, one got filed twice. So that's why it was rejected as a duplicate, because it was. But this was October 22. But later, when the reply were due and were filed, with that reply, one of the documents that was attached to it was a declaration signed October 22. It was a declaration of Jim Sekulich and Brad Sekulich in response to WSLB's, or however it was, motion for summary judgment. And then subsequently, there was a document called Notice of Deleted Declaration, and attached to that was the exact same declaration again. So, Mr. King, this declaration signed by those two gentlemen on October 22, is that the one that you expected me to get with the response, and therefore have I got everything I'm supposed to have?
That is correct.
All right, and so that's good. I always like to make sure when there's a question like that. Now, in terms of how we're going to proceed today, there's technically two motions, the cross motions for summary judgment. Technically, what you do is you take the moving party for motion A and have them argue with a response from the opponent and a reply, and then you go to motion B and do the same thing with the moving party, responding party, and moving party. But I have found when you're dealing with cross motions for summary judgment, all I do is hear the same stuff I heard in round one, in round two. It's not particularly helpful.
Right.
And so this is how, but by the same token, I want to make sure everybody gets fully heard. And so I have an approach that I've been using. If there's an objection, I'll listen to it before we begin. And that is that I'm going to expect each of you, when you're arguing, by each of you I mean Mr. Miller and Mr. King, that you're going to, based on your choice, you're either going to argue why your motion should be granted, or you're going to argue why the other motion should not be granted, or you're going to do both at the same time, whichever suits your strategy best. But I'll hear first from Mr. Miller, then from Mr. King, back to Mr. Miller, and conclude with Mr. King. Somebody gets to get the last word, and that's the way I've been treating it when I have cross motions. Is that acceptable to you, Mr. Miller?
Yes.
And is that acceptable to you, Mr. King?
It is, yes, Your Honor. I've done some work in this area too, and it is difficult when you have the competing motions like that, and I think that's a workable solution. Thank you.
Thank you from both. Now, before we start argument, I need to see if there's something else that we need to address preliminarily. Is there anything we need to address from your side, Mr. Miller?
No, Your Honor. We're ready to proceed.
Okay, Mr. King?
No, there's not.
All right, then, Mr. Miller, please go ahead.
Thank you, Your Honor. Refusing to accept the lawful consequences of its choices cannot exempt Raccoon Hill from its responsibilities as a liquor licensee. The licensee would prefer to argue about ADN 3E1015A. However, this proceeding is an appeal of ADN 3E1091A. Now, for the sake of clarity, I'll be referring to ADN 3E1091A, which is appealed here, as the current ADN. And I will refer to ADN 3E1015A as the prior ADN. Enforcement believes that summary judgment is appropriate here because our credible, admissible evidence shows that on April 1st of this year, while its license was suspended, the licensee allowed an employee to sell alcohol to Captain Dixon. WAC 314-29040 clearly prohibits the sale of liquor during a liquor license suspension. And under WAC 314-29020, the appropriate penalty for the violation of a liquor license suspension is actually serving the original suspension penalty, plus an additional 10 days for the new violation, with no monetary option. Here, that means the current ADN imposes a 15-day suspension for violation of the prior ADN 5-day suspension. All of the material facts to the outcome of this case are not in genuine dispute. On February 17th, Officer Stevenson issued the prior ADN to Brad and Ken Zuckelich, longtime members of the LLC and supervisory employees of the licensed business. The prior ADN that unless the licensee appealed or paid an alternative monetary penalty, the period of license suspension would last from 10 a.m. March 31st until 10 a.m. April 5th. The licensee did not make a timely appeal and refused to pay the alternative fine. Therefore, the period of license suspension began at 10 a.m. on March 31st. Then, on April 1st, the licensee sold a growler of Black Raven beer to Captain Dixon. The licensee has argued that its successful obstruction of LCB officers' attempts at posting a public notice of the suspension somehow exempts them from needing to comply with the prior ADN license suspension. That argument is a legal dispute, not a factual one. Enforcement readily acknowledges that the officers were obstructed from posting the public notice on the morning of March 31st. This fact is attested to by every officer who was present that morning and supported by their contemporaneous reports. Further, the licensee's members clearly knew that the suspension period became effective at 10 a.m. because otherwise they would not have assembled an obstructing crowd in front of their bar that early in the morning. WAC 314-29040, Section 2 and Section 3 state the clear constraints on a licensee's business operations during a license suspension. These suspension conditions are independent from the Section 1 directive to enforcement officers to post a conspicuous public notice. The licensee has failed to credibly allege that any material facts are actually in dispute here, and summary judgment is appropriate to resolve this case as a matter of law. Their continued refusal to accept these legal consequences does not exempt Raccoon Hill from responsibility for its actions. Thank you.
Thank you, Mr. Miller. Mr. King, your opportunity. Please proceed.
Yes, Your Honor. Briefly, this at the outset, just by way of opening, this tribunal emphasized at the outset that the parties are here to operate in good faith. We believe we can show a substantial question as to whether or not LCB has actually operated in good faith. And that is kind of the cornerstone of where we're going to go. Before we get into the substantive arguments, I will preserve for the record what we are going to agree is the prior ABN, the 3E1015A. And just for the record, I understand we're sitting right now on it, but I will state again that in the discovery request that I've shown to the tribunal, we have asked LCB to demonstrate any inkling, any iota of evidence that they actually had authority to initiate enforcement of the masking mandates. They are not mentioned in the mandates, nothing. There's no statutory construction of the masking mandates that makes any reference to them whatsoever. So we contend, again, that ab initio, they had nothing on jurisdiction, and you can't grow jurisdiction out of a stone. They still never had jurisdiction. So that's preserved for the record. And so to continue on from there, with respect to some of the factual allegations involved. First of all, they have never, look, when we talk, let's talk about the initial sale. Oh, no, let's go back, actually. Let's go back to the first instance. It was uncontroverted that at the time, Jim Sekulich did not know that the first ABN was going to be issued. That's why he referred LCB to Brad and Kemp. Otherwise, since he is the manager, he would have been present. I don't think they disputed that. So they lost an opportunity to really negotiate with the major domo in that instance. Okay? But then, before the so-called suspension ever happened, it was uncontroverted that Jim Sekulich said they told him that Shell Warner was going to, there were 2 phone calls on the 30th. And there was misunderstanding as to when the suspension would start. And LCB representatives told him that, first they told him early in the day that somebody would be calling him to work something out on the 30th. And then further, that they called back later and dropped the name Shell Warner would be contacting. But he called back, right? And they got the name Shell Warner. So the licensee phoned back in, not trying to ignore them. He phoned back in. And they said, wait for Shell Warner to call you. This is uncontroverted. Nobody called. And so they knew that there was a possible suspension coming. But so that's why he called everybody and everybody assembled. Okay? Yes, that they lawfully assembled. Nobody was charged with disorderly conduct. Nobody was charged with threatening. Okay? There were no guns. There were no visual carries of the sort. People were there to exercise their First Amendment right to protest and petition the government for redress. And so we're getting there, Jim. So, and I referenced the screenshot and the video link that I provided, where one can see that when the officers showed up there, I know how the officers laid out, and I know that just behind where Jim was over there to the right, that's the door. There was no throng of people in between the LCB officers and that door. They could have walked right there and put the notice on the door, and that's going to become important in just a second here. Bear with me. But they didn't do that. And you can hear on the tape, they say they're going to come back. So between what was going on with Shell Warner waiting on that phone call that never came, and the fact that the agent said they'll come back, Jim and everybody else was confused as to whether or not they were actually under suspension. And to take it one step further, I kept reading the enforcement's declaration, and in it, they said that they contacted the sheriff, and that there were actually not one, not two, but 3 deputies were available to come back to help assist, I guess, in this scary throng of revelers or what have you. And guess what? They didn't go back. So when they didn't go back, there was substantial confusion. And the point of the matter is, how do I know that? Because LCB's own agent and documents we provided to the court, Sanchez, who was present,
he questioned whether or not they had properly been served or whether or not the suspension had started. So, with all, and as a matter of fact, and Jim had also said that he wanted the sheriff to be there too. So there's no threat there. And that's in the LCB's own words, that he had called the sheriff as well. So they had no threat whatsoever. That's not credible. And at that point, they don't come back. And just waiting on the phone call from Shell Warner, notice how the LCB does not put an affidavit in for Shell Warner. Okay, that's missing from the file. That would have been helpful, but it's not there. And we are arguing that all of those things are indicia of the fact that they were trying to get this resolved and just got confused. That's something that doesn't call for a maximum penalty, but calls for a penalty at all. Let me just take a look at a couple more things here. Oh, yeah. Also, we had noted, controverted, that the SEC was trying to make the area safe. They kept the back door and multiple windows open for airflow. They cleaned and sanitized per state requirements. They had ensured there were people and tables maintained 6-foot spacing. The only exception to this was when elderly or disabled people sat at the bar while ordering their beverages. And obviously there's an argument there, Your Honor, under public accommodation for elderly handicapped. And the only thing that was wrong was the O2 sensor. There was a time period where they had to have an O2 sensor, and they missed that, but they ordered it right away. By the time they got it, I think that had been suspended anyway. So they were not looking at some willful scofflaws here. And I think lastly, yes, we come back to this allegation of a threat. Okay, this is a way that governments deal with people they don't like. They make you into a threatening person. Well, certainly there was no threat greater than would have been addressed by 3 deputy sheriffs. And they said that Mr. Deputy should issue some type of threat to them. But when we asked what was the threat, they had no credible statement for what the threat was. And what the point of that is, their response to the discovery was to say, oh, his threatening behavior is not the basis for the suspension. That's not our argument. Our argument is, in a way it is, because your language and portraying him and his First Amendment practitioners as threatening shows their bias. And that is not good faith. And that's part of the problem of this whole proceeding. And with that, I think I'll turn it back over to my opposing counsel. Yes.
Thank you. Mr. Miller, your opportunity.
Yeah, just a few things. First of all, the licensee obviously is continuing to want to litigate the prior ABM and the conditions regarding COVID-19 precautions that were not taken. I think that is not an issue here. That ABM was not appealed in a timely manner, has not been appealed, and is settled at this point. The current ABM is the reason why we're here. And as far as that goes, the LCB has not alleged that there was a threat that is necessary for us to suspend the license. Does not allege that any hostile physical threats were issued. One officer in his testimony, in his declaration, referenced that his belief at the time was that it was a hostile situation with multiple people standing between him and the door, and tried to defuse that situation by leaving. That was the reason why the sheriff's office was initially contacted. So by the time that we received confirmation that the sheriffs were available to be present, felt that it would not be wise to further escalate the situation. Regardless, the non-posting of the public notice does not relieve the licensee of their duties to suspend their sales of alcohol license suspension. Thank you, Your Honor.
Okay, just let me catch my notes up. Thank you. Mr. King, please go ahead.
Yeah, just briefly, Your Honor. It's fruit of a poisonous tree. And as a legal maxim, we all know that subject matter and personal jurisdiction can be waived, but subject matter jurisdiction can never be waived. And since LCB did not have an ab initio and they refused to show it, I know if I were in LCB's position and I had somebody sitting across from me saying, show me your authority, I'd pull out look, that's like pulling a trump card. I'd pull it out, slam it on the table and say, here you go. Here's 4 aces, you know? But they can't do that. So, yeah, you got to prove the poisonous tree issue. And the main thing is, outside of that, in terms of any type of willful violation here, it doesn't make any sense that the LCB's own agent was unsure as to whether or not a suspension had started. Given that, it doesn't make any sense for them to allege that the licensee concretely knew if they didn't know. It was Cynjo, as I mentioned earlier, Jim. Yeah, it just doesn't make any sense, Your Honor. So they can't show a willful violation if their own staff didn't know. And I can't make it any clearer than that. That's like, you don't need law school to know that. That just makes no sense. And I'll rest on that.
Thank you, Mr. King, and of course, Mr. Miller. Appreciate you both being succinct. But your oral arguments have contributed to your written arguments, and I appreciate that as well. I'll issue a decision within 30 days. If I grant either motion entirely, then that will dispose of the case. There will be further appeal rights, just as if it had gone to hearing, and those appeal rights will be attached to the order. And it'll be clear within the body of the order as well that the rest of the case schedule has been struck. If I don't grant either motion, or I grant one or the other partially, that will be clear as well, and that also will mean that the rest of the case schedule remains in place, and the party should prepare accordingly. And there'll be no appeal language there. If the decision does not dispose of the case, you still, of course, have the right to appeal any decision by me, including summary judgment, but that ripens once the case is disposed of later. And then everything that I've done is kind of an open book for people to look through if they believe that that's contributed to their loss in the case. Any questions, concerns, or other matters we should address before we adjourn, Mr. Miller?
No, Your Honor. Thank you very much.
Thank you. Mr. King, same question.
No, Your Honor. Thanks for your time and professionalism. I appreciate it.
Thank you, everyone. And this motion hearing is concluded. Good day.